Okay, guys, welcome to the first Empower Me Wednesday hosted by the South Carolina Jaycees. For those of you who don't know, the Jaycees are a young person's leadership organization. We're dedicated to empowering our members to become young leaders and to create a positive impact in their community. Today, we have Greg Steele from Greg Steele Law, who's going to talk to us about estate planning. And go ahead and take it away, Greg.
Thanks, Jeremy. I really appreciate the invitation to come and talk to you today a little bit about the basics of estate planning. I'm glad that there's organizations like the Jaycees out there that are trying to engage young professionals in service. And I think that's really important. I also appreciate Jeremy for putting this together and helping members think about something that I think a lot of people generally kind of have a vague idea about. But I'm hopeful that I can kind of give you an idea of what are some of the basics, what are some of the things to think about as you're moving forward and thinking about an estate plan, and give you some information that you will be able to take and run with in your own life and help formulate your own estate plan. So as Jeremy mentioned, my name is Greg Steele. I've had this first slide as just kind of a little introduction to me. I am in Anderson, South Carolina. I was born and raised. That picture on the left is me and my dad. My dad was a judge in Anderson for 25 years, and he retired, I guess, about 10 years ago. And he was also a lawyer and a judge. And then up top right is my wife, Janessa. We met at school. I went to undergrad at a small school called Covenant College up near Chattanooga, Tennessee, where we met. Started dating. I went to law school at the University of Georgia. She followed shortly thereafter, and we got married and finished that. She is now a licensed master social worker and does outpatient therapy for the Department of Mental Health with the state of South Carolina. We live here in Anderson. And that's my mom down at the bottom right with my dad and my wife. She is a first-generation immigrant from Hong Kong. She was a paralegal there before she moved to the United States and married my dad. So I have a rich legal heritage. Very grateful for them both. I moved back with my wife to Anderson close to 2 years ago. About 6 months ago, I opened up my own practice, Greg Steele Law, focusing primarily on family law and estate planning. And that's why I'm here today to talk to you a little bit about estate planning. So I am a lawyer, so you have to expect some disclaimers up front. I think that's with every lawyer. You expect to hear some legalese. And basically, I just want to cover a few basic things before I launch into the meat of my presentation. And that's just everything I'm presenting here is legal information. It's not legal advice. It's not tailored to any of your unique situation and circumstance. Because of that, attending this webinar doesn't create any sort of attorney-client relationship between you and me. And I would encourage you to actually take what you learn in this presentation and go reach out to an attorney and get advice on what you might specifically need in place to put in place so you're protected, your family's protected moving forward. So with those disclaimers, I'll jump right in. The first topic I kind of wanted to consider is there's a couple ways to tackle what you need in place for estate planning, but I think the first step that's really key is understanding what is a probate versus a non-probate estate. So you probably heard of the probate process, probate court. There's a probate court in every county in South Carolina, and that court is designed to help people who either have wills or who have died without a will move through the legal process of probate to get their assets legally transferred out to other people. There are certain assets, however, that you have that can pass outside of the probate process. So they don't have to go through that legal court process to be able to transfer your interest in them. So in looking at the probate estate versus your non-probate estate, as I mentioned, your probate estate has to pass through the probate court upon your death, and it will pass either according to what you have in your will or what's called the laws of intestate succession, which is basically if you die without a will. It's through that process that property gets titled into that new person's name. That's part of that court process. And at the end of the day, you have probate fees that are calculated based on the value of the assets, and then you pay that into the court. A non-probate asset is property that can pass to someone else immediately upon your death without having to go through the probate court. Often, all that's required to transfer those assets in your non-probate estate is a death certificate. You just present the death certificate, and then you're able to move forward. So I wanted to go through some examples of what would have to pass through the probate estate. So what is a probate asset and what is a non-probate asset? So examples of a probate asset would be property in your name only. If your car is just titled in your own name, that's a probate asset. If you have a bank account that's only in your name, that's a probate asset. If you have a retirement account, like an IRA or a 401k, you have not named a beneficiary on that account, your name is the only name on it, that's a probate asset. If you have real estate, even if you either owned in your own name or even if you own it with someone else, but the way it's titled is as tenants in common, that also has to pass through the probate process to pass that 50% interest that you own in that property. Some examples of non-probate assets would be joint bank accounts. So if you and your spouse have a bank account together, that basically upon your death, your spouse could show your death certificate to the bank and they would take that your spouse's name, your name off that joint account. Same as if you go to the DMV and have your cars titled as or designation, then it belongs to either or. Either person can sell. It passes automatically to the other person upon death. Life insurance or retirement accounts where you have a named beneficiary. So again, the spouse is always a very easy example to use. But if you have a life insurance or a 401k through your work, you have contacted those companies and said, hey, I want 100% of these life insurance benefits or 100% of this 401k to go to my spouse upon my death. Then that, again, you just have to notify the life insurance company or retirement company, financial company of the death, and they will transfer that. And then finally, real estate that is titled jointly with right of survivorship. Often people don't know whether if they own joint property, whether it's tenants in common or right of survivorship. It has to do with how the language is in their home deed. That's something, again, a little beyond the scope of what we had here, but that is a distinction to remember when you're going into planning is, hey, is my house jointly titled as tenants in common or right of survivorship? Because a jointly as tenants in common, that house will have to pass through probate. You'll have to pay fees on the 50% that's getting transferred out. Whereas if it's a joint tenancy with right of survivorship, again, it passes outside the probate process. You never have to go to court for that. So why do I cover this at the beginning? Why I do is because there are a lot of, I guess, for lack of a better term, estate planning things you can do that will keep things out of the probate process and allow them to automatically pass to someone upon your death. So there are a host of reasons why you might not want to have a joint bank account, why you might not want to jointly title your vehicles. But if you and your spouse say, we had two separate bank accounts, we've just never joined them and closed one, it's just out there, that would be something I would consider thinking about. If you want to leave everything to a surviving spouse in the case of your death, be thinking about, well, how can I set up these assets to pass outside of probate for them to be non-probate assets, and for me to not have to hassle with going through the court, going through that long process that can hold up some of those assets as well while the court process is continuing, and just automatically have it go to a surviving spouse. So those are some initial things to think about when you're thinking about, hey, what are my assets and what am I moving forward? So today I'm going to cover basically the basic estate plan documents that most people think of when they think of estate planning, and that I would say every single person needs at least these in place. I will say that the trust is the exception to that. I touch on trusts because I think they're important to touch on, particularly if people have children. But I'm not going to go into depth. That's a more advanced estate planning tool. But the three, what I call the trifecta, are the will, power of attorney, healthcare power of attorney. Those are three things I say that almost every single person needs in place moving forward, and needs to get those things in place. And we'll cover kind of what those things are. If you do need something beyond that, certainly, again, as I said at the beginning, I would talk to an attorney about your specific situation. There might be other estate planning tools and more advanced estate planning techniques that you might need to incorporate into your estate plan. But the will, power of attorney, healthcare power of attorney are something that everyone should have in place in their estate plan. So I'm going to start with what happens if you die without a will. So if you die without a will, we talked about probate versus non-probate. If you die without a will, your probate estate, all those assets that are not jointly titled, that have to go through probate court, pass by intestate succession. And I put in there where you can find that in the South Carolina Code. There are rules that, again, kind of expound upon each other based on who are the surviving relatives of the person who died, also known as the decedent. And I listed some of the common ones here. So example of those intestate succession rules. If you were to die, you have no spouse, you have no kids, all your property would be divided equally between your parents. If you were married, but you have no kids yet, everything would go to your surviving spouse under these default rules. And if you have a spouse and children, half of your property would go to your spouse and half would be divided equally among your children. And that doesn't matter if your children are below 18 or above 18, they're minors or not minors. If you die without a will, that's how the property is divided up. So that's why I cover those default rules first, because that's what's going to happen if you were to pass away tomorrow without a will in place. So some of the reasons you need a will in place is it allows you to alter those default rules of intestate succession. So maybe if you are single, you wouldn't want your parents to get all your assets. Maybe you want to leave them to a charity, or maybe you have friends that are particularly close to you that you want to leave property to. Unless you have a will, it's going to go to your parents. So the will allows you to alter those default rules and leave your property how you want to ultimately leave them. You're not bound by those default rules. It also provides absolute legal clarity as to what you want to happen to your property upon death. A lot of people say, well, I've told people, they know what I want. They know how I want. They know I want this special set of china to go to Sally. But at the end of the day, if you don't have that with the legal clarity of a will, then there's no one to be able to enforce that. The court can't enforce what you told people while you were living. They're just relying on what is in front of them. In the case of parents, it allows you to name a guardian for your minor children in the event that both you and your spouse were to die together, which again is a possibility that's not great and comfortable to think about, but is a possibility, and it allows you to name that guardian, that alternate guardian, in that document. And it also, this is why I said we'll touch briefly on trust, it allows you to provide for your minor children until they reach an age they can manage property for themselves. Their property isn't going to be automatically divided out and given to a standard custodian. You can put things in place and have things to how you want those assets managed for the benefit of your children until they hit a certain age. Some people even in their wills will say, hey, I don't trust my kids until they're 35 or 45 or 50 with my assets. And you can do that in a will. So it really, again, allows you much more flexibility. You're not bound by those default rules. So I'm just going to briefly cover the requirements for a valid will in South Carolina. I will say I do not recommend you doing your own will. I know there are a host of services out there like LegalZoom, other kind of print your own forms. Wills again, have to be executed properly. They need to be in the right format. And it's really helpful to be able to speak to an attorney who can talk to you about all your assets. Make sure that what you're actually wanting to do in your will, you are actually accomplishing in the will, rather than kind of saying, well, I'm going to print this form and fill it out myself. But regardless, I also want you to know what you actually have to do to make sure your will is valid, regardless of whether you do speak to an attorney or not. So the section for the requirements of the will are found in South Carolina Code 62.5.502 through 504. The will has to be, the signing, the execution has to be in writing. So you can't do like e-sign, digital signature. It has to be in paper and ink. You have to have 2 disinterested witnesses. And there are some complicated rules about when someone who is receiving something under a will in South Carolina, they might be able to inherit some of it. If there's an additional 2 other witnesses to the will, it might still be valid. But really the best rule is 2 disinterested witnesses, people who are not receiving anything under the will. That ensures that the will not be able to be altered because of someone receiving something as a witness. And it may be self-proved by a special attestation signed in front of a notary. So that self-proving basically kind of, again, that language basically means it adds some extra evidence to the fact that you indeed intended to do what you said you wanted to do in the will. However, a notary is not required to execute a valid will in South Carolina. The one requirement is those 2 witnesses. So that's what you have to have in executing the document moving forward. So how do you go about making a will? As I said, I would recommend speaking to an attorney, but I would take a couple steps first. I would first take inventory of all your property. Go through all your bank accounts, financial accounts, cars, real estate, anything you have, and make sure you have captured a complete list of everything you own. After that, have discussions. If you're married, have discussions with your spouse, have discussion with other family members about what you want to happen upon your death. Who would be you want to be guardian of your children if both of you were to pass away, if you and your spouse were to pass away and you do have children. If you're worried about those finances being managed, who would you want to manage those finances for your children until they get old enough? Talk to people about having those things in place. Talk to your family so you can go in and not say, I don't, when you first talk to an attorney, I don't know, maybe this person, maybe that person. Talk to them ahead of time and say, hey, if both of us were to pass away, would you be willing to be guardian for our kid? Someone else say, hey, I need someone to manage my kids' finances. Would you be, until they reach an age of majority, if I were to pass away before they hit that age, would you be willing to do that? And then finally, I would say contact an attorney. An attorney can ensure that all the language is correct, that you've properly executed your will, and just make sure that you're accomplishing what you think you want to accomplish when you're making that will. But you'll also be ahead of the game if you're able to have some of those discussions ahead of time, if you're married, with your spouse, with your family members, about, hey, this is kind of the idea of what I want to happen. And then you can go to the attorney and say, here's what I want to happen. And that attorney can say, hey, here are the ways that that's realistic and we can make that happen. Here are some other ways that maybe think about this in a different way. So that covers wills. I'm going to very briefly touch on trusts. A trust is another legal document tool. It can be created by a will. And if a will creates it, it's known as a testamentary trust, or it can be in a separate document. A testamentary trust that's created in a will does not come into being unless the will is probated, which means someone has to die, whereas a separate trust or a living trust is created as soon as you create that document. Trusts also generally, unless it's a testamentary trust, pass outside of the probate process. But there's a lot of complicated rules, and I don't want to take a deep dive into trusts today because they are a more complicated estate planning document and not one that I think everyone needs. I will say that basically what I did want to cover is that how trusts work is you deed over property or hand over property to a third party. And that third party is known as a trustee. And that trustee holds the property for the benefit of another person. So we're talking about the children situation. Let's say you and your spouse died. You left a testamentary trust in your will that said, I want all the money to go to Johnny and Susie. However, Johnny and Susie, if they are under the age of 25, I want that money to go into trust. I want to name Uncle Joe as the trustee. Uncle Joe is to manage those funds for the benefit of Johnny and Susie. He's to make sure that that money goes to cover educational expenses, living expenses, whatever else. And Uncle Joe will manage those funds, but he's not allowed to just use those funds for whatever. Uncle Joe has to use it for the benefit of Johnny and Susie. So that's why I wanted to cover what a trust is. As I note here, testamentary trusts are often used in wills to provide for minor children. So there'll be some sort of provision that says, if my children are under a certain age, I want this money to pass, or I want this property to pass to them through a trust. But if by the time I die, they're above a certain age, then you can go ahead in the will and probating the will. I'm going to distribute this outright to them. So again, I don't want to die that I know I threw a lot at you, and that's why I didn't want to do an in-depth dive, but I did want you to understand that's kind of what a trust is. And that is a mechanism both within a will or separately from a will that you can provide for, particularly for minor children. Moving forward. Okay, so next I'm going to cover powers of attorney. Powers of attorney, I note again the code title and article that covers powers of attorney. The way I describe it to everyone is it clones you for business purposes. It's basically making a copy of yourself for all your financial and business dealings. A power of attorney can generally buy property, sell property on your behalf, open bank accounts, close bank accounts, take out life insurance in certain cases as long as they're not the beneficiary. Again, they're supposed to use that power not for their own good, for your benefit, but it is a wide-ranging power, and I describe it as cloning yourself because it really does. If that person has that power of attorney, they can walk into a bank and open up a bank account tomorrow on your behalf because they have that power of attorney. The execution requirements are found in 628105. You have to have the signature of yourself, the person who's giving the power of attorney, who's known as the principal. You have to have 2 witnesses, and this is a circumstance where it does have to be notarized. So you have to have a notarized acknowledgement with the power of attorney for it to be valid. Many people, when I describe it as cloning you for business purposes, say, why in the world would I ever want to give someone that power? And the reason is if you were to become incapacitated. For older individuals, particularly those in their 40s, 50s, 60s, who maybe have a family history of Alzheimer's or dementia, they're worried about not being in place where they can conduct their own business on their behalf. Power of attorney allows that family member or friend or whoever you name to conduct that business on your behalf. If you were to get into a horrible car accident and, again, lose a lot of your functioning and your ability to conduct business and manage your financial affairs, a power of attorney allows that other person to step in immediately and manage that. The alternative is to seek a guardianship through the probate court if someone is incapacitated, and that is a long and expensive process. If the person who's trying to seek guardianship has to hire a lawyer, there has to be a guardian ad litem appointed for the alleged incapacitated person. That alleged incapacitated person has to be appointed a lawyer as well. And it's a long court process with hearings and fees. And it's, I mean, a power of attorney is a fraction of the cost of going through guardianship proceedings. So I always tell people, if you want that safety net in place, it can save you and your loved ones a lot of money and a lot of heartache and a lot of court time down the road. But at the same time, you want to make sure you're granting that to someone you trust, because although they're not supposed to be self-dealing, they're not supposed to use that power of attorney for their own financial gain. Often that is just, it's too late by the time someone else discovers that someone is doing that. So I would say I don't advise against power of attorneys, but at the same time, you want to think carefully about who you're giving it to, because it is a lot of power and you want them to use it responsibly. The last document I wanted to talk to you about today is a healthcare power of attorney. I again have put the SC code title that is relevant there. It names someone to make end-of-life healthcare decisions for you if you are incapacitated. So this, again, is the situation where you're in a horrible car wreck, or in our current times, maybe you contract COVID and are on a ventilator. You are not able to make those decisions for yourself. So if you don't have a healthcare power of attorney in place, those healthcare decisions automatically fall under the Adult Healthcare Consent Act. Generally, that falls to a spouse. But again, if you have children and there's two kids and one kid says, I want to pull the plug on mama, and the other kid says no, those are the situations that you're trying to avoid with a healthcare power of attorney. It also allows you to make some of those decisions ahead of time. So there's actually blanks within the document that you can initial, that you can instruct your agent. Hey, do I want life-sustaining treatment if I'm in a vegetative state or medically determined not to be able to recover and can't make that decision for myself? You can say ahead of time, I don't want treatment, life-sustaining treatment. Take me off life support. Or you can say, give me the maximum amount of treatment. Or you can say, I'll leave it up to this person I named in this document. Those are all options under the healthcare power of attorney. The same options go for nutrition and hydration if you're in the vegetative state or medically determined not to be able to recover. And you can also make decisions ahead of time about whether you will allow your agent to donate your organs upon your death. The form comes directly from the statute. And that is why I say this is the one document, estate planning document, that I say is fairly DIY. I've put a link in the PowerPoint to the South Carolina Bar website. If you also just Google SC Bar Healthcare Power of Attorney, the state agency governing lawyers, the South Carolina Bar, actually has created a healthcare power of attorney form that you can download and fill out. That's why I say this is the most DIY, user-friendly one. It's often pretty cheap because attorneys know that it's coming from the form, so an attorney can help you and advise you through that process. And it's generally an add-on to something like doing a will with a power of attorney and a healthcare power of attorney. But I would say if this is something you want to get in place yourself, it's the most user-friendly. You could probably manage it yourself and execute it correctly yourself. The form is going to be the same from the statute. It's, do you want someone to make sure you're there to help you think through those decisions, make sure everything is executed correctly. But just as I said, with a will and a power of attorney, I do always advise people, hey, go speak to an attorney about getting these in place. Healthcare power of attorney is kind of the one document that I could say, hey, you probably are okay handling it yourself. So I wanted to wrap up with a few general estate planning tips when you're thinking about getting your estate plan in order. Have an open, honest conversation with your relatives and loved ones about what you want to happen after your death. Obviously it doesn't have legal force, but being upfront and having those frank discussions, even if it's hard, often you'll get good input from them. You'll make your wishes known, and you can say, hey, this is what I want to do and what I hope to accomplish. And they can give input. And I even though as I said in the will section, you shouldn't leave it up to chance. You can, a will allows you to put those things in stone. At the same time, I've found family members often are very loving. They're very caring. They want to honor you and honor your wishes should you leave this earth. And I think it's always best to have those open and frank conversations in a loving way up front. Take an inventory of all your property and debts. Know what you have so you can know how you want to leave it. Make sure, again, go over what is titled how. Go over, you as part of your estate, you'll have to pay off any debts. So, take an inventory of that and say, what am I leaving, and is there going to be anything left over? What is it going to look like at the end of the day? And then also, how do I want all these, what are all these assets that I do want and need to leave moving forward? And then I would say, finally, contact an attorney sooner rather than later. It sounds like I'm an attorney. This guy has a vested interest in getting attorney's business. And to some extent, that is true. I am an attorney. I do make a living helping people with things like this. But at the end of the day, an attorney is going to be able to help make sure everything is done correctly. Often, particularly these simple estate planning documents are often way more affordable than you would think. And an attorney, as part of that, will be able to help you talk through those options too. They'll be able to not just say, okay, well, you tried to do this in a will. They'll be able to say, okay, well, let's do this. Let's take an inventory of your assets together. What are some other things? We talked earlier about the joint tenancy as tenants in common versus joint tenancy with right of survivorship. An attorney might be able to look at those deeds, help you figure out, maybe you wanted to get it transferred over from a tenants in common to tenancy with right of survivorship. An attorney can talk you through those choices as well, whether it makes sense for you at this time, whether it would make sense for you to do that on your next home. It just, again, is helpful to have that relationship and someone who can speak into what exactly is going on with you. What do you need to accomplish in an estate plan? Because what you want to accomplish is going to look different from what I want to or anyone else other than you wants to. So that's basically the presentation. I am now open to any questions anyone might have. All my contact info is on this slide. My address, website, phone number, gregsteelelaw.com, 864-326-4468. I'll be happy to answer any questions now. And then if you have any questions afterwards, feel free to give me a call or shoot me an email. I'll be happy to answer anyone's questions that they might have.
Greg, that was great. Thank you so much. Hey guys, if you have any questions, please go ahead and post those in the chat. There was one or two. For the power of attorney, if you do not have one, does that defer automatically to someone, just like how the will or the probate or non-probate things do?
No, you would have to go through a guardianship. So again, there's no one, if you don't have a power of attorney, no one has the right to conduct business on your behalf. Someone can't buy and sell property that's yours. However, if you were to become incapacitated, let's say you were in a car accident and then end up in a vegetative state, and someone else wanted to sell your house so those funds would be free to help treat you medically, they would have to go to probate court, file a petition for guardianship, and get guardianship over you to be able to do those things.
Okay, that makes sense. I see another question here. If someone dies and you're not sure if they have a will, how do you go about finding out if there was one?
That is one of the hardest questions for everyone. I get emails probably weekly from my local, like Anderson listserv, saying, so-and-so died. They're looking for a will. If anyone did a will for this person, please let us know. So I always tell everyone, and that actually is an important point that I didn't put in the presentation. Once you get a will, different attorneys do it differently. For me, I'll always leave only one original with the person, and I always say whoever's named as your personal representative in the will. And that's actually probably something that is helpful to cover too. In your will, you generally name a personal representative who is someone who helps get it through that probate process I talked about. So I always tell people, keep your will in a safe place. Keep the original, because a copy is not good enough for court. Keep the original in a safe place. Let whoever is supposed to be the personal representative under your will know where it is, so that they'll be able to access it and get it to probate court upon your death. Because if the will's lost, I've known even people who maybe they found an electronic copy somewhere and they've searched high and low and can't find the original. If you can't find the original, there's very rare circumstances that the probate court will allow that copy to go through the probate process. You have to have the original.
Okay. Trying to think. Oh, so another question was, as far as with the will, are you able to put like kind of legally binding language of what you want to happen to your remains after you die?
That is not something you can do. You can put in your wishes regarding that. I actually came up this with a client who wanted to donate their body to science. And you can enter into an agreement with MUSC to do that, but ultimately it's the people who, your loved ones and relatives who end up doing that. That's one of those conversations that I'd say have with your family members, those loved ones close to you. Very rarely, I guess you might have a situation where your closest member of your family has a very strongly held religious belief for or against something specifically. But I've found that most family is willing to honor whatever your wishes are regarding how you want your remains to go.
Okay. So you can have it spelled out in there, but it's not legally binding that they have to.
Right. And at the end of the day, I usually say, don't worry about putting it in the will, because usually by the time the will gets to probate, you're already in the ground. To be honest, that the probate process, some people open it up immediately, but with grief, and it's a hard time, it's a grieving time. Most people start thinking about probate 3-4 weeks, a month, 2 months out after all the initial things are taken care of, burial, remains, all those sort of things.
Okay. I'm not seeing any other questions. Anybody else have any quick questions before we go ahead and sign off? I have another question here. Someone asked, how long does probate normally last? So after it actually gets started, how long is that process?
Yes. So generally speaking, and I didn't want to cover the whole probate process because it's its own animal and its own beast, and there's all sorts of different documents and forms you have to file. Generally, it lasts anywhere from 8 months to a year in the overwhelming majority of cases. You can access some of that property ahead of time. Some of the property you might be able to distribute out ahead of time, but the reason for that is there's a period of creditor claims that lasts. Either you publish a notice to creditors and then that expires either at a certain period of time after you've published that notice or within a year of death. So usually the probate estate has to remain open to allow the creditor period to run, make sure no one files claims against the estate, and it allows basically secret debtors to come out and say, hey, this person actually borrowed money from me. Here's proof that they borrowed from me, and I want to get paid before everything goes out to someone else.
Awesome. Okay. Not seeing any more questions. So again, I want to thank you, Greg, for coming on. Great presentation. I think you cleared up a lot of things that people weren't aware of.
Absolutely.
So again, we appreciate it. And for those that don't know, again, this is our first Empower Me Wednesday. We're hoping to do this every couple Wednesdays, kind of as a trial run, and then see if, based on attendance, if it's something that membership wants. But yeah, thanks again, Greg. Appreciate
Absolutely.
it. So I'm going to end this.